Will you take the oath, please?
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Please have a seat. Yes, Mr. Clark.
Thanks, sir. Just start by giving us your full name, if you would.
Victoria Evans.
Thank you. Could we have on the screen, please, your statement? So it's CTPHQ 506. This is your statement to the inquiry. You've indicated that there's one correction that you wish to make, I think. Could we deal with that now? Could we look, please, at page 7 of the statement, and it's paragraph 32. Could we just have that expanded, please, Sarah? You say there that at the time of all three referrals, so December 19, February 21, April 21, the CTP Prevent Network was using the Prevent Policy version 2, dated May 18, and then you say that a further version was brought into effect in August 2020. And that's got the inconsistency on its face, I think, that a policy was brought in 2020, but the August 2020, but the old one was still being used in February 21 and April 21. From the correction, I've understood that that's not right, and you provided a correction. I'm just, with your permission, going to read the correction into the record for what we should replace at the start of paragraph 32. So you've asked for a correction to be made as follows. At the time of AR's referral in December 2019, the CTP Prevent Network was using the Prevent Policy version 2.0 released in May 2018, titled Policy for Prevent Practitioners, Management of CTD Risks Within the Community, same reference. A further version was brought into effect on the 28th of August 2020 and was in use at the time of the February 2021 and April 2021 referrals. This updated version reflected the 2008 policy, but updates and builds upon the previous content, and then the wording continues. Is that your correction?
Yes, except you said 2008 policy and it's
Forgive me,
2018.
2018. Thank you. With that correction, are the contents of the statement true to the best of your knowledge and belief?
They are.
Thank you. If we can go back to the first page of your statement, please. You explain in paragraph 4 of your statement that you're currently the Senior National Coordinator, I think the acronym is SNC, for Prevent and Pursue. Is that right?
That's correct.
And working within Counter-Terrorism Police headquarters. I don't need to go through it. You very helpfully set out the dates of your predecessors, so that we have the dates and the post holders for the whole time in which AR had some involvement with Counter-Terrorism Police. But I think you took over this role, is this right, in May 2024?
That's correct.
Thank you. You've been a police officer, just looking at terms of your history, if we go over the page to paragraph 5, over 20 years experience, including as an assistant chief constable in both Cambridgeshire Constabulary and I think also a period in Difford Powers.
Yes.
Thank you. Relevant to some aspects that we've been looking at in the inquiry as well, you were previously the National Police Chiefs Council lead on the implementation of the Manchester Arena inquiry recommendations in relation to emergency response.
Yes.
Just keep your voice up a little.
Apologies, yes.
Thank you. Just say that we're clear in relation to the ambit of your evidence. Is this right, as you make clear in your statement, that neither you personally nor Counter-Terrorism Police headquarters had any direct involvement in the handling of the 3 prevent referrals for AR?
That's correct.
I think what you can assist with in your role as the Senior National Coordinator is to look at the policies that were in place at the time and the training that was in place at the time and the role of CTPHQ in overseeing that sort of policy and guidance.
That's correct.
Thank you. Your responsibility as SNC covers prevent and pursue, and I think that you have an equivalent colleague who deals with the aspects of protect and prepare. So you have two of the contest strands within your policy responsibilities.
I do.
Thank you. Can we look as my next topic, please, at the meaning of counter-terrorism police headquarters and how it sits within the counter-terrorism police network. So it's paragraph 7 of your statement going into paragraph 8. What is meant by the counter-terrorism police network? Can you just explain how it works?
So the Counter-Terrorism Policing Network is a collaboration, and we work on behalf of the Chief Constables of England and Wales and work closely with Police Scotland and Northern Ireland. So we're not an organisation per se, but we are a network that is set up under a Section 22A agreement, and we work on behalf of all of those Chief Constables to deliver the response to counter-terrorism policing and the contest strategy in a policing context.
Thank you. So looking at the numbers, I think there are 9 regional counter-terrorism units or counter-terrorism intelligence units. Is that right?
Yes, in England and Wales.
Yeah. Each of those regions will have a number of police forces within it.
Yes.
And one of those would take the role of the lead force and would host the regional unit.
Broadly, yes. It's slightly different in each region, but that's broadly the concept.
Effectively that. Thank you. And in this case, obviously, we've been dealing with Counter-Terrorism Police North West, hosted by Greater Manchester Police, I think.
That's correct.
Thank you. And we don't need to go into too much detail in relation to this, but just so that we have a feel for it, how does it work in London?
So London has a regional unit, which is SO15, or Counter-Terrorism Policing London, who performs that function. But we also have what we call CTP HQ, so Counter-Terrorism Policing.
Leave the HQ for a moment, okay. Just in terms of the regional equivalent. So there's a London-wide, and that's effectively SO15.
That's correct.
So the language may be slightly different, but that you still have that consistency of a regional counter-terrorism unit for London.
That's correct.
Thank you, and forgive me, I interrupted you. You were helpfully going to go on then to deal with CTPHQ and how that sits within the network.
Thank you. So CTPHQ is hosted by the Metropolitan Police, but it is made up of officers seconded from up and down the country, and we work on behalf of the network to provide that strategic support and coordination. So we sit as an overarching entity to support the network.
Thank you. And in your statement of paragraph 9, you say it's best understood as a coordinating feature. Is that right?
That's correct.
And so for the uninitiated, should we be clear in our minds that in that role of coordinating, you've said it provides the strategic support and coordination, that's very different, isn't it, to a directing headquarters? I don't think CTP HQ directs what the individual counterterrorism unit should do in respect of individual referrals or individual prevent cases.
So we would provide policy and guidance, but the operational delivery and the day-to-day operational oversight is the responsibility of the CT head, excuse me, on behalf of the chief constables of that region.
Thank you. So with possibly very rare exceptions that we probably don't need to go into, the running of a referral and the decision-making would be for the local counterterrorism unit, in this case CTP Northwest.
That's correct.
But you would expect them to be following the guidance and practice and policy that may be set down by CTP HQ?
We would, if they choose to deviate from that because there's a specific nuance in their region, then they would obviously record that decision and account for that under their own local operational control.
Thank you. And then CTPHQ, I think, not acting entirely independently, because as we heard in evidence yesterday from Ms. Elsmore, the overall framework and policy is set by the Home Office.
That's correct.
But whereas the Home Office, as we heard from Ms Elsmore, has a more, my words not hers, hands-on role in guidance and training for other prevent agencies, local authorities and so on, would it be right that CTPHQ fulfills much of that function so far as the police is concerned in giving guidance and policy?
CTPHQ would lead the operational policy for policing, but as outlined yesterday by my Home Office colleague, we do work collaboratively and consultatively as we develop that policy and guidance.
Thank you. If we look at paragraph 16, you say, thank you, that CTPHQ continually seeks to enhance the network's capabilities and learning is drawn from a variety of sources, including but not limited to academic research, internal and external reviews of major incidents, relevant recommendations from assurance bodies, inquests and public inquiries. How does that work in practice?
So in practice, we have what we call capability leads across a number of areas, and we have one that specifically focuses on interventions, which Prevent is a part of. And that would be gathering through our own learning, so business assurance processes, Dignate reviews, Prevent learning reviews. We also scan nationally and internationally for learning and relevance material that may then influence our policy. We work with the Home Office, who also gather some of that information. So there's a variety of mechanisms and sources where we gather that information from, and then we will consider whether that needs to make changes to policy or training.
Thank you. Can I ask a preliminary question at the risk of getting ahead of myself? How do you, at your level of seniority, strike the balance between continually adapting and changing and improving and having so many versions of policies that those on the ground can't keep up?
So clearly we need to take that into consideration, and that's where we will broadly look at themes. So actually, are there themes where we can retrain and update? I would flag, because I'm conscious the versions of our policy documents, there is one in particular where we are on version 3.6 and you will see multiple iterations. Not all of those iterations are published and shared with the workforce. They are working copies and versions of that document.
Yes.
So even when we are in quite high numbers, it isn't the case that the workforce have received every single iteration of that. Each policy will be different, but broadly they will only receive once that policy is finalised and there are substantive updates in it. That's evident here in that we were working on the 2018 policy that was in place and not updated until 2020, so a two-year period.
I follow. Thank you. So far, we've touched particularly on, at a high level, on guidance and policy. What's the position in relation to training? Is there a common standard, a common content for the training even? How much discretion do the local units have and how much is set by CTPHQ?
So there is a common foundation course for Prevent at the time of the referrals that we are talking about. That was called the Prevent foundation course, I believe the terminology was. That was a central product that had a core content, and similarly now there is an updated version of that course, and that is still a centrally owned product by our organisational development unit, who are the training leads across CTPHQ. We also deliver ad hoc training and inputs through our capability lead, which is a headquarters function, but equally local CT heads and their teams have the ability to deliver local training based on the policy and products that exist if they feel there's something that they want to do within their own local teams. So there are layers of training, but there is a foundation course that is national.
Thank you. So when there is a development of policy, and let's take as an example the way in which the policy on mixed, unstable or unclear ideology became amended or given greater emphasis. We'll come back to the joint 2019 letter. Presumably, CTPHQ would think about the foundation course training and might amend the foundation course training, yes?
Yes, that's correct.
What about those who've already been through the pipeline and have done the foundation training? Is there some mandated top-up training or annual refresher training that's also comes down from CTPHQ? Or are the local CTUs left to ensure that that sort of update change in policy is trained to their staff?
So it depends on the level of change. So if, by way of example, the 2018 policy, which was a new policy and a substantive document that I refer to in my statement, that was rolled out through sort of national get-togethers, as it were, where teams were pulled together, and then also cascaded through the regional prevent coordinators. It will be hosted on a specific site on our intranet, so officers and staff can access it. We also then have multiple other ranges of mechanisms, so we will host online training events. We have what we call Prevent Bite Size, which it's an interactive online platform. So it does depend on how significant the nature of the policy change is. Currently, we have a process now where there is what we call a notification that goes out to regional prevent coordinators, which is documented and audited with the instructions of how they cascade that. And in addition, we may hold national training events. So it does vary.
Thank you. I know it's second nature to you, but the regional prevent coordinator, is that effectively the senior officer in each CTU who is responsible for prevent?
It is, yes.
Yeah. And their rank would normally be?
It varies depending on CTUs and CTIUs. They are usually sort of chief inspector or police staff equivalents.
Thank you. Can we turn then, please, against that background, just to understand your role just a little bit more. Against that background, what is your responsibility against that role that CTPHQ has?
So as the Senior National Coordinator for Pursue and Prevent, I'm the senior officer who oversees that strategic coordination and direction. As you've referenced, I also have some other specific roles around incident response and have the ability to take national command of an incident if it is necessary to ensure that we resolve the threat, but that's probably less relevant to this scenario. Often
in very senior leadership roles such as yours, when you take over and you learn what's been happening, you might form a view. For me, taking on this role, this is something that I know needs to improve, needs to change. Did you form those views in May 24 when you took over? What was top of your do list on a strategic level?
I think the reality is the prevent system had already changed and evolved. It's a continually evolving mechanism, as is Pursue. What was a very live topic and still is for all of us in counter-terrorism policing is the very large breadth of the threat and the number of children and young people that we see within our casework across the board, and the impact of online content and how that impacts on that. That wasn't a new thing. A substantial amount of work had been done before my tenure, but that was a very live issue and continues to be for all of us.
And the broad concept of mixed, unstable and unclear ideology, does that straddle those two areas of particular concern, children and young people as a high number of the caseload, and the potential for the radicalising effect of online content?
So we don't actually use the term mixed, unclear and unstable anymore. We stopped using that, I would say, probably about 22, 23.
I understand, but I'm using it because it was the terminology that was used originally, and we can look at how it's been picked up and changed and has more subgroups, but just focus on that envelope of concern for the moment, regardless of the label.
It certainly can form part of that. It's not the only factor, because we do see some children and young people who have a very fixed ideology and in probably a more traditional sense, but equally the breadth of harmful content that children and adults and vulnerable people can access online certainly contributes to the concern.
Thank you. And if I fall into what you may think is the error of referring to mixed and unstable and unclear ideology, will you take it as referring in modern terms to the different classifications, including those who may be labelled as violence-fascinated individuals?
To some degree, violence-fascinated individuals are not all necessarily relevant to counter-terrorism policing, because it is a very broad term.
I'm just talking in terms of labels. If I use mixed and unstable and unclear, will you take it, unless I indicate otherwise, that I'm referring to a number of the current classifications that would all come within that old banner? Do you follow?
Absolutely.
Thank you. Turning then to contest and prevent, much of this ground has been covered with other witnesses. We just look at paragraph 8 as a brief refresh in your statement, please. So the bottom of page 6. Prevent, pursue, protect, and over the page, prepare. You've made clear that prevent is about preventing individuals from becoming terrorists, but also about rehabilitating those already involved in terrorism. Those two strands, is that correct?
That's correct.
I want to turn to the prevent duty guidance in this respect, please. That the 2015 version that was in place at the time. So it's CTPHQ 4011, please. And what I'm interested in here is how the strategic objectives have changed. So if we can go within that, so this is the 2015 version, Deputy Assistant Commissioner, all right? Yes. And if we could go to page 4, please. And we see on the bottom half of the page, under paragraph 6, the yellow highlighting perhaps doesn't make it so easy, but the 2011 Prevent Strategy has 3 specific strategic objectives. Respond to the ideological challenge of terrorism and the threat we face from those who promote it, prevent people from being drawn into terrorism, and ensure that they're given appropriate advice and support, and work with sectors and institutions where there are risks of radicalisation that we need to address. Now, if you just keep those in mind for a moment, could we have on screen CTPHQ 4012 to look at the 2023 equivalent, so after all of AR's referrals. So this is the 2023 Prevent Duty Guidance. And Sarah, it's page 8, please. Paragraph 17 in the top right. Post Shawcross, that becomes the objectives of Prevent are to tackle the ideological causes of terrorism, intervene early to support people susceptible to radicalisation, and enable people who've already engaged in terrorism to disengage and rehabilitate. Yes?
That's correct.
Now, while one sees that obviously the overall objectives are similar, there are significant differences between those. And in particular, the first bullet point, as we look at it in the 2023 version, appears to have narrowed down to place the emphasis on tackling the ideological causes of terrorism, yes?
It does, yes.
What was your understanding as to the reason for that change?
So that was detailed in the Shawcross review, that it was felt that Prevent should refocus on probably its sole purpose when it was first created around ideological causes. That was the view of the review.
and your professional assessment of that now, looking back on it, particularly in the context of our current case, looking at somebody who might be described as having a fascination with extreme violence, but without a clear ideology. Was that a positive change or a problematic one, do you think?
I think in operational reality, our approach didn't dramatically change, because what our officers were concerned in was the vulnerability and now susceptibility to being drawn into terrorism, and our policies, the DIF and all of the documents that supported it still reflected that, because we were working very much upstream, there could be a broad range of things that could impact on somebody being susceptible or vulnerable to being drawn into terrorism. So whilst I accepted at a very high policy level the nuances there, it didn't dramatically change our operational application of the vulnerability and susceptibility to being drawn into terrorism, because the threat is broad.
So if it were to be suggested that the narrowing down and the first objective may have been unhelpful in placing undue emphasis on ideological causes, should I understand from your previous answer that while you see that as a linguistic nuance, operationally you don't think it had that effect?
I don't believe it did, because we didn't communicate that as a change of direction in any significant way to our workforce. We, as I say, are focused on the susceptibility and the vulnerability of being drawn into terrorism, and that can be a very broad range of factors.
Thank you. It might be thought that the emphasis in the second bullet point on early intervention was a forward step and a helpful one, and that links, doesn't it, with the phrase that you used in relation to acting upstream. And should we understand that what you mean by that is that you're not necessarily looking for attacked offence, preparation of attacked offence with a clear ideological cause? Because if the person who's being referred has reached that stage, that's likely to be in pursue, yes?
That's correct.
By upstream, should we understand that you're looking at hopefully an earlier stage where the person being referred may be in a position where they are susceptible to being radicalised, and you're trying to effect interventions before they go further down the dangerous terrorist river?
That's correct.
Can you give us your blunt assessment of this? Are these sort of changes to how the fundamental strategic objectives of PREVENT, these sort of changes from year to year, are they difficult for CTPHQ to manage in terms of what you have to put into policy and what you have to train and teach?
I think any reviews and the recommendations are helpful, because they are normally in response to something, whether that's a significant incident, a change in the threat mechanism. So they are helpful. Our job is then to ensure that we translate them into something that is operationally workable and doesn't confuse or create too many updates for the workforce. And we're able to do that because the definition, or the, apologies, not the definition, but the approach of being susceptible or vulnerable to being drawn into terrorism allows us to have a very flexible decision-making framework.
I'm conscious, of course, that the learned chair will tasked with looking at what further reform may be due, but it's right to explore with you this issue a little bit. Does the number of changes and the pace of them cause a problem? Is that itself a difficulty?
Not dramatically, because Mr. Shawcross's review was 2023. This is now, so they are not so frequent that they cause significant changes. I think what is always important with any recommendations is us to have the ability to understand what is the outcome we are trying to achieve, and then have the flexibility to decide how we can deliver those operationally within what is a much larger counter-terrorism system.
Thank you. I want to move, as my next topic, please, to look at some of the CTPHQ policies specifically. Again, much of this ground has been covered, but I want to focus on the national level policing policies. So could we start, please, with the May 2018 CTPHQ policy for prevent practitioners? That's at CTPHQ 4014. And can we go first to page 5, please? We see there in the middle of the page, Deputy Assistant Commissioner, that there are further objectives for prevent, which are different to the strategic objectives that we were looking at a moment ago. What's the purpose of having a differently expressed list of strategic objectives?
So those are specifically for policing, whereas the government contest strategy clearly impacts on all of those who have a duty and also is a public-facing document. These are strategic objectives for operational policing colleagues.
Thank you. If we go to page 14 within this, please. So within the policy for prevent practitioners, we see a section 6 on the police gateway assessment. And we've heard a reasonable amount of evidence about this. By way of brief recap, at a high level of summary, would it be fair to say that this is the first threshold that a CTCO would have to apply, and it would come at the stage after the FIMU has done the deconfliction exercise?
So stage 1 is the FIMU deconfliction exercise. Stage 2, which is the CTCO, conducts an initial assessment using the Prevent Gateway assessment and then applies the reasonable grounds to suspect test for it to move to the next stage.
Thank you. So if we see the box at the bottom, the PGA has been designed, could we just enlarge that? The PGA has been designed as an initial assessment and triage tool, and as such should not require additional research with partner agencies. The Dynamic Investigation Framework, the DIF, and the Vulnerability Assessment Framework, the VAF, come after the PGA, and both require more detailed research, yes?
It does. It's actually, the DIF came in shortly after this policy was published and was used as part of the Prevent Gateway assessment at the time of the first referral, which is why one was filled in.
That's exactly why I wanted to take you to this, because on some of the policies, would you agree that that's quite confusing? Because if you were to look at this, you would think there's the PGA and the DIF is something different, more detailed research, and it comes afterwards. But in fact, you're telling us that what all of the DIF or aspects of the DIF were expected to be done ahead of the PGA?
Yes, and there is a document, forgive me, it is produced in my statement, and I think it's probably Exhibit 15 or 16, which is the DIF guidance, which came out shortly after this. That was in the play at this time and was known to practitioners, so they would have been aware the DIF was required.
Thank you. So I'm going to come to an aspect of the DIF in due course. You touched on the test, and it was intended, was it not, to be, at this stage, the first threshold, a relatively low test for getting through the threshold?
That's correct.
And a decision, as we've covered with others, to be taken by the CTCO?
By the CCTO, but then the supervisor has a responsibility.
The sergeant will look at it and approve or question, yes?
So it's a recommendation from the CCTO supervised by the sergeant.
What it is not is a decision for the FIMU.
That's correct.
And of course, the FIMU will be providing information, a readout of the intelligence or lack of intelligence, which you would fully expect the CTCO to take into account in making his or her recommendation. Yes?
They take it into account, yes.
But not the role of the FIMU to direct what the overall outcome should be of the PGA.
No, the FIMU conducts the deconfliction assessment in line with Annex B, and that is effectively the pursue relevance test, as we would call it now, referred to by them as CTDE then, and then the CTCO is looking for that different consideration, which is prevent relevance, which is a much lower threshold because we are not talking about investigation and pursue standards.
Now, we've been exploring with the individual involved witnesses and with the CTP Northwest corporately examples of how in AR's referral it might be suggested that what was at least written by the FIMU may have overreached. I don't seek your comment on exactly what happened in AR's case, but I do seek your assistance on whether that is a problem that you recognise, that the distinctions between the role of the FIMU and the CTCO are perhaps not always as clear and as well understood as they should be.
I think the roles are distinctly defined in the guidance in a number of different documents and still are. The pursue test is a specific one, as you referred to earlier, as to whether somebody needs to go forward for further investigation. The prevent test is different. I'm fairly confident from speaking to practitioners that they understand those roles and then their responsibilities of the decisions they have to make against the tests they have to make.
In other reviews, I'm not asking about AR's case now, but in other reviews, have you looked at the paperwork in relation to prevent referrals and seen examples of where the FIMU's language may be suggesting that a case might be suitable to be closed, or where language around a lack of CT, counterterrorism, DE, domestic extremism, intelligence is at risk of being equated with nothing of prevent relevance?
I wouldn't want to mislead the inquiry and say whether I've seen that specifically or not in other reviews. I think the difference being the language they use may lead to that consideration, but the CTCOs do understand their responsibilities and the decisions. So irrespective of what the FIMU writes, the CTCO should and is clear through policy and guidance and training as to what their role is and what assessment they are making.
Assuming that the CTCO has the experience and knowledge not to over-defer to what may look like a direction from the FIMU.
Yes, that could always be a risk. However, then you have layers of supervision to check and support decision-making.
Thank you. The outcomes from the PGA, again, I'm going to take this briefly because we've explored it with others. Recommendation for closure, as you've dealt with, to be checked by supervising sergeant. Could go forward to multi-agency-led or a police-led process or police-led partnership. Yes?
Yes.
The stage for, if it goes through to a multi-agency-led outcome, is that where, in the old terminology, the vulnerability assessment framework would come in?
That's correct.
Who would then do the vulnerability assessment framework? Have I understood it correctly? Would depend upon whether or not the unit was within the dovetail trial or not?
That's correct.
If you were within the Dovetail trial, the VAF would be done by the local authority channel coordinator.
Yes.
But if you were not in Dovetail, that would be done by the CTCA.
I believe so, yes.
Thank you. We just look at the Dovetail policy, please. CTP HQ 4045. Because it does add a layer of complexity, but if we look at the flowchart on page 8, and if that could just be enlarged, please. If we see at the bottom left the stage reached that passes initial screening and police have suspicion of a vulnerability to radicalisation which requires further consideration by multi-agency panel, that would be the PGA stage?
Yes, so that's the reasonable grounds to suspect decision at the end of the PGA.
And no, the exit process is shorthand for the recommendation checked by the sergeant. Would you agree?
The recommendation should be checked by the sergeant whether it's a positive
yes,
or
but
an exit.
Sticking with what the exit process would involve.
Yes.
I'll come on to if it was recommendation to go forward, but the excess process would involve, in fact, 2 stages, the recommendation and the check by the sergeant.
Yes.
All right. You follow the arrow up. Dovetail cases, then, you would, in the old way of doing things, you'd have to get the information onto the local authorities or the system CMIS that the local authority could use. Is that right?
Yes.
That agreement, as you've indicated, that it should go to the local authority for information gathering would itself have to be approved by the sergeant?
As part of that gateway
At the gateway,
decision,
yeah.
yes.
And then you see that the local authority channel coordinator is the person who's gathering the information from all relevant partners, looking at whether there's sufficient information for consideration as to whether it should be adopted by the panel, yes?
Correct.
But then, in fact, it goes back to the police under Dovetail for the police to make the formal decision at the next level as to whether it's suitable to be referred to the panel.
So legislation dictated that the Section 36 decision was a police decision. I think my Home Office colleague covered yesterday there was a slight amendment to the legislation at some point, but ultimately the police would take into account all of the information and assess at reasonable grounds to believe at that point.
Thank you. So if we had a extension of this for non-Dovetail cases, it would be a similar process but carried out by the police.
But still multi-agency information gathering.
Thank you. The review of Dovetail as a pilot, that can come down from the screen, thank you. The review of Dovetail as a pilot found that there was friction in some sites between the counter-terrorism police and the local authority. First of all, are you familiar with that?
Only having seen reference to it in documents as part of the review of this case.
It's not something that you have personal knowledge of?
No, however, I would say I wasn't in the network at the time of that process, so I wouldn't necessarily have seen it if it was evident then.
Thank you. Against that background, I'm going to come back to the Dignate review of AR's referrals in a little bit more detail later in my questioning, but can I ask you a preliminary point about it, please? So it's CTPHQ 4028. So this is Counter-Terrorism Policing Headquarters badged report. And if we go, please, to page 3. We can see that this is the executive summary. So I wonder if we could just have the final bullet point highlighted, please. So it said this: these cases took place at a time when Dovetail was in place in the region. This may have contributed to some of the decision-making, and this is explored further in the learning observations at the end of the report. Since its inception in 2012, Channel has been managed and led by counter-terrorism police, typically prevent officers. However, in 2016, a new approach known as Dovetail was trialled to move ownership of channel into local authorities. The new local authority-led channel approach did not change the process of channel referrals or delivery, but changed where some of the functions of the process and delivery were managed. Just pausing there, that's exactly what I've been looking at with you. Would you agree?
Yes.
Thank you. The trial took place in 9 local authorities and ceased in 2024, and we remind ourselves that you took up post in May of 24. It's apparent from the facts in these cases that there was enough to get any of the 3 referrals through the police gateway assessment into Dovetail information gathering. So just pausing there, that seems to be within the executive summary, a finding of the review commissioned by CTPHQ, that from the facts in these cases, there is enough to get any of the 3 referrals through PGA into Dovetail information gathering. Do you agree with that?
That was the assessment of this review and also the PLR.
Yes. Do you agree with it?
I do.
Thank you. From there, the local authority coordinator would have gathered the VAF and multi-agency information. However, each time the case was entirely police-led, and then these words, seemingly with a reluctance to share the risk-stroke decision-making with the Dovetail lead. And then it goes on to say, it has been observed in some Dovetail sites, CTCAs making a decision at PGA based on the Section 36 threshold, rather than of suspect, therefore more cases being closed at PGA than in other regions, which didn't have Dovetail in place. Do you understand upon what evidence the Dignate report concluded that there was a seeming reluctance in AR's referral to share the risk decision-making with the Dovetail lead?
It's just based on the reviewer's observations would be my assessment. I haven't explored in depth why they came to that conclusion.
Can you just help us with this? Did the Dignate process, was that effectively a detailed desktop review, or did it involve interviews of the officers concerned?
It is a detailed operational desktop review. It didn't include detailed interviews with those who made the decisions.
So we should understand that to be a view formed by the Dignate reviewer or reviewing team based on the documents that they had assessed?
It's difficult for me to say because I wouldn't want to speak for them. A number of our colleagues in our interventions capability have worked within Prevent for a period of time, so it could have been their general knowledge about the outcomes of the Dovetail pilot and review as opposed to something specific. It would be unfair of me to speculate because I don't know.
But I think what you can tell us in terms of process is that that wouldn't have come from direct discussion with the officers or the sergeants involved.
That's correct, I believe.
Thank you. That can come down from the screen. We're looking here at how the system used to work in a region such as CTP Northwest, where Dovetail was involved. To the interested outsider, the system does seem quite a complex one. Would you agree?
I think I can understand to somebody not within the system that it appears complex. I think, like many police and multi-agency processes, there are a lot of parts and connecting parts that make up the process. So I do appreciate it can look complex. That's why we have policy training and guidance, and our staff are subject matter experts in the area they work in.
As part of that complexity, you have not just a multi-staged process, some of it led by police, some of it involving different agencies and multi-agency. But you also have strapped on top of that different threshold tests at different stages, and then a trial which amends in some areas who does the tasks. Are you able to give a view as to whether the complexity of the process in general terms does create operational challenges? And I'm going to ask you this in the context, and this isn't a reflection in my question on any individual from whom we've heard evidence, but in the context perhaps of less able staff within the cohort who are working at ground level. Is it not an awful lot to take on and to follow?
I think the reality is that, as described by my Home Office colleagues, it's about 6 stages, and each is quite clearly defined. The reasonable grounds to suspect and believe tests are very familiar to police officers. They feature in an awful lot of legislation, including even their powers of arrest. They're familiar terminology. So the reality is it is a staged process that helps us triage what are a very broad range of referrals from the public and referrers, which is what we want to then be able to distill down and understand the risk. So some of the nuances of what you need to consider to make those decisions are complex, because radicalisation and counter-terrorism and safeguarding and vulnerability is complex. But the actual structure and the number of decision-making points, I wouldn't say is any more or less complex than an awful lot of other decision-making processes that we deal with in policing and broader safeguarding.
What about, because I think you're seeking to give a level of reassurance that complex to the outsider, but once you understand it and once you're trained in it, that they're familiar tests and it's understood. But what about to the agencies on the outside? Do you think that the other agencies, education, to take an example, local authorities, to take another, healthcare providers, do you think in general terms that they have a sufficient understanding of these complexities to be able to work effectively with Prevent?
I think that's very difficult to answer, because the level of knowledge will vary from local authority area to local authority area, depending on how often the individuals interact with Prevent in their roles. Clearly, the Home Office lead the training for those who have a duty to cooperate. I would clarify, when I say and give reassurance that the actual process isn't that complicated, what I would say is we ask our practitioners to make very difficult and finely balanced decisions. So that's not to suggest that the decisions they have to make are simple. I was just really saying the actual steps in the process can be broken down and are straightforward to work through. The decisions are very difficult.
Yeah. And I may come back to that in a different context. Thank you. Where the decision is against accepting somebody at the PGA stage, would you agree that in most cases it's important to look at updating and informing the referrer, if it's a school, for example, or a healthcare provider?
Sorry, could you repeat the question?
Yeah. If the decision, as it was in AR's case, is this person is not going to be taken through for consideration for channel, so the case is going to be closed. If the referral has come from a school or healthcare provider or from local frontline police, is it important to liaise with the person who made the referral to explain what the outcome has been?
It's important to liaise with the person who made the referral to understand the facts, to conduct the assessment. Whether then the officer needs to respond back to them, that can vary. It would be clearly preferable, but I would suggest if there's any suggestion that there's an outstanding risk, an action that needs to be taken by that referrer, for argument, if you are referring it back to that person to then continue support because it's not suitable for this process, then that would be particularly important.
And important in that context, because if there are continuing vulnerabilities that may include a risk of violence to others, in terms of understanding who is going to take forward the mitigation of the risk, it's really important then that the referrers understand clearly if Prevent is not taking the case forward.
So policy references what we call onward signposting, and that can either be back to the original referrer or to other agencies. It also depends on what the broader context of the case sits within. So if there are already live engagements by those agencies and they are aware, for instance, in strategy discussions. So how that's communicated will depend on what steps are being taken throughout the whole process.
All of that is true, but without discourtesy, what's the answer to my question? Is it not important in the sort of case where there is ongoing vulnerability and a risk of violence to others, that if Prevent is not going to take the case forward, that the other agencies are informed of that?
If there is an ongoing risk or something that they need to be aware of.
There may be all sorts of other cases, but in that scenario, that would be important to communicate.
If there is a risk, yes.
Thank you. And in that context, I'm not talking here about a cold call from a member of the public saying, I've heard something that's a bit concerning. I'm talking about professionals who make a referral in. Of course, there may be exceptions where the sharing of information may be sensitive and so on, but in broad terms, the Prevent process would be prepared to share with fellow professionals, teachers, clinicians, local authority, social care, that the fact that Prevent had looked at the case and were not taking it on.
Generally, it can depend on the circumstances, if there's particular sensitivity or vulnerabilities as to why that wouldn't be appropriate. So a lot of these decisions are then case-specific on the circumstances, because Prevent is not a punitive process, so it's important that we signpost on, make people aware of risk, but equally it's important that we don't unintentionally create a situation where Prevent is seen as a marker against somebody. So there are nuances to those engagement, but where they're partners that we are regularly engaging with about these considerations as part of the multi-agency information, then clearly we have information sharing agreements with them.
Now, we don't need to go into the precise mechanics about markers and how markers can work in some cases on the PNC, beyond knowing that that is something that can be done. One of the issues that arises in this case in relation to AR's referrals is police officers on the front line after the referrals not being aware that AR had been referred into Prevent, and certainly not knowing that that happened on 3 occasions. In general terms, is there a difficulty with frontline constables, response officers, being able to access that information? Is there any security or counterterrorism policing concern about that being something that's quite visible on police records?
So we obviously work and utilise different systems because we're in the counterterrorism system for obvious reasons. We don't routinely place markers on individuals when they are in assessment processes and they've not been adopted by Prevent, because we have many thousands of people who are referred into Prevent each year and actually are then exited out of Prevent because there's no concern. So that would be really inappropriate to place Prevent markers on individuals who had been in good faith referred into the system but weren't to be considered. There are mechanisms to share and break out intelligence into false systems if it needs to be broken out. Again, the sensitivity would depend on the context of the referral and any wider information as to what could be shared.
But in AR's case, against a background of serious criminal offending, where there'd been a serious assault with one adapted weapon used and a knife carried, against a background that had been raised in the Prevent referral of researching school shootings and asking about imagery of severed heads and of guns, all of that was known, and then there was a further concern raised at the strategy discussion in December about an interest in the Manchester Arena attack and it having been a good battle. Leaving aside for one moment whether that should or shouldn't have led to further to being adopted at the PGA stage, that sort of a case where there are concerns that there are mental health vulnerabilities but there was information of concern, if it didn't meet the threshold, it is something that would have been valuable for frontline officers to know, wouldn't it?
Yes, it would be valuable. Your point about, I think an awful lot of that had been shared in the strategy meeting where local police colleagues, and obviously there was a criminal investigation ongoing, which again would have had information that would have been available to frontline colleagues. I'm not aware of exactly what
Forgive me, but you say that, but part of the complexity of what we have to look at is the fact that that was in a strategy discussion, but it didn't filter down, it seems, in Lancashire Constabulary record keeping to records that would have been readily visible to frontline officers. Now, there's a local police force issue about that, but I'm asking you for the moment to put that to one side and look at it from a CTPHQ process. And essentially, I suppose it comes to this. Is there a case for CTPHQ recalibrating how it approaches closed referrals to play a part in making sure that on police systems it is more visible to frontline officers that somebody has been referred into Prevent but not taken on?
I think it's certainly something that we can look at and should test our current policies and process to ensure whether that's effective or not.
Because faced with a decision about simplifying the actual circumstances on the ground, but faced with a decision about how to exercise discretion in circumstances where AR was later found to be carrying a knife, it stands to reason, doesn't it, that information about Prevent, that there may have been enough to look at somebody for Prevent, is in itself relevant information to how that discretion should be exercised.
I think it's helpful for frontline officers to have as much information as they can to inform their decisions, whether under discretion or under use of powers.
And would this be fair that, of course, there may be individual cases that need to be looked at and where it may be difficult, but if on the whole the Prevent process is prepared to share with outside professionals that a case has been looked at and has been closed, but there are remaining vulnerabilities and we need to keep an eye on the risk, there wouldn't seem to be good reason for that not to be shared with frontline police officers.
I think there is a difference between sharing it with named individuals who are actively working and supporting an individual in a case versus putting a very broad marker on systems in case the nuance if that is lost. But clearly, as I say, that requires us to check our current processes and ensure that we consider what the current sharing is and whether that's sufficient.
Thank you. But your evidence is that is something which you would agree perhaps needs to be at least looked at, but is it for that reason that it being available to police forces in that very wide way, there might be some concern about that compared to a narrow group of professionals who are directly involved?
I think it would be difficult for me to say specifically. I think we need to explore what the cause and effect of each action is to make sure that it's safeguarding the public, most importantly, and the information is getting to who it needs to, but that there are no unintended consequences or risks around those things, as with any process.
Thank you. So could we turn now, please, could we go back to CTPHQ 4014? This is back in the 2018 policy for Prevent practitioners, Deputy Assistant Commissioner. And could we just go to page 8? Could I just raise with you a brief point about the training requirements? You mentioned the foundation course, and in the middle of the page we'll see that the requirement is that CTCAs will complete the National Prevent Foundation course within 6 months of starting the role. And we don't need to turn it up, but sir, for your note, I think that at page 10 there's the equivalent for sergeant supervisors. Understanding real-world issues about training courses being put on and the need for them to be perhaps at set times and they can't be put on for individual officers. Is that acceptable, do you think, that somebody can start the CTCA role without having done the foundation course for as long as 6 months? And we've heard that in individual cases Constable Thompson's was longer. Is that acceptable, do you think?
That was the policy position at the time. It is now that it should be completed as soon as practicable, and there are online courses if it's not sooner. Clearly, my preference would be that people are trained as soon as possible. I would add, though, that they would have the support of their peers, their supervisors, and be shown how to conduct the process and given that mentoring and support when they arrived in role, even if they hadn't conducted that course. But clearly, the sooner the better.
Yeah. And the duality that could be the case for the CTCO and the sergeant meant that at least theoretically you could have a CTCO making a recommendation and a sergeant approving it with neither having gone through the foundation course.
That is possible, yes. I would expect then local supervisors and local leaders to understand the training needs of their workforce and be alive to that and be supporting them appropriately, and also those officers to use their general and basic policing skills, national decision-making model and understanding risk and safeguarding to support them in their decision-making.
Thank you. The current practice that you mentioned, the requirement that it be done as soon as practicable and that there are now online courses if necessary, on the face of it, that sounds a positive step. Is any check actually done, an audit done, of how quickly after appointment CTCOs are currently doing their foundation course?
So that would be the responsibility of the CT heads through their operational ownership of their individual regions. There are central records as to who has completed courses and the numbers that are held within the ODU.
And do you know what picture those central numbers paint?
I would have to get those right. I'm sorry, I don't know that detail here today.
Thank you. The 2018 policy was then updated in August 2020. Perhaps we can just deal with this before we take our morning break. So CTPHQ 30 is 117.
Apologies. Could I just add, for reassurance around training, we have now brought in the PAF, which is the new assessment framework, and that was mandatory training for all staff. So I can here today give the assurance on those numbers because I do know that to be correct, that all staff had to go through that mandatory training, and it's now built into the foundation
on the
training.
PAF, the PAF.
So as far as the current risk assessments, all staff have completed that.
That's helpful, thank you. So in relation to the updated version, I think here, is this where you were mentioning your point about version 3.5 and so on. Version 3.5, it may be, but it's not like an IT update. This is the first version of the updated policy that would have gone out to members of staff.
I believe that's correct from the next page, yes.
Thank you. And you say that this, in your statement, that this substantively reflected the 2018 policy, but clarified some of the language used within it, including removing the CTDE references. Is that right?
That's correct.
Why were they removed, to your understanding?
It was in recognition that the phrase CTDE was something we were no longer using, and it could be misinterpreted, so a particular focus on either UK-based concerns or international concerns, and we moved to the broader term around pursue or CT relevance and then prevent relevance. So it was to remove any misinterpretation of the terminology.
Thank you. So current language, and I think that continues now, does it? That what one should now be seeing is pursue or CT relevant, juxtaposed with prevent relevance, where the prevent relevance is a much broader category.
That's correct.
Thank you. We go within this to page 38. Could we have the top quarter of the page highlighted? We see again the complexity, but I'm not going to ask you more about that. We've dealt with that. We see information intelligence direct referral coming in at the top, partner referral, local intel, other CT or non-CT, and then we've got the deconfliction stage with the FIMU assessment. And it says there, create a new case as soon as referral is received, and then FIMU CTCO gatekeeper completes mandatory checks. The RADO process then determines suitability. Now, that reference to the RADO process then determining suitability, in one sense, is this fair? That's accurate, because if the RADO outcome was in favour of needing a pursue response, so criminal justice in simple terms, type response, it wouldn't be suitable for prevent.
That's correct. Or if it was considered, it would need to be considered for different mechanisms. So for prevent as a multi-agency, it wouldn't be suitable.
But even here, in the modified language, in trying to get away from the language of CTDE, saying the RADO process then determines suitability, that is there not still a risk that, at least in this flowchart, that the FIMU's role is prone to be misunderstood? Because the RADO process, in another sense, shouldn't be determining the suitability for prevent at all.
No, the RADO process is a separate process in the intelligence world, and that's deciding on those outcomes. I think I can understand your point looking at it as somebody from outside of the system. I think those within the counter-terrorism system understand that there is a FIMU process and there is a prevent process, and whenever you condense or summarise words, you are going to lose some of the granular detail that is in the more detailed documents.
If we look at CTPHQ 30114, please. This is the NSIM, the National Standards for Intelligence Management, Annex B, for prevent. And if we go to page 3, the learned chair has seen this with a previous witness. And the bottom of the page, please, under section 4. I'm not going to read it all out because, as I say, we've had it read into the record previously, but this is making clear that the RADO outcome, even in layperson's terms, the bottom outcome, RADO 6, specifically does not mean that the case is not suitable for prevent. And this was warning against FIMUs giving intelligence a grading of RADO 6 and then not passing it on to prevent, wasn't it?
That's correct. Annex B was brought in, my understanding is in 2018, I don't have the specific date, to address the fact that there needed to be absolute clarity that the FIMU needed to pass those referrals with those outcomes on to prevent so that the prevent tests could be conducted.
And taking your point about any flowchart condensing language may have these, are you really confident that these distinctions were understood at this time in 2020?
As confident as I can be, I think, and it's very difficult to say the level of understanding in every individual in large teams, but I'm confident that it featured in training, the policies were updated appropriately, and that people understood their roles, and then you have supervision to support that process.
Thank you. So I'm going to turn to a different document, still on the same topic, but I wonder if that might be a moment to take perhaps a 10-minute mid-morning break.
Certainly. We'll sit again between 25 and past. Please have a seat.
Thank you, sir. Deputy Assistant Commissioner, can I seek your assistance next, please, with more CTPHQ policy? So I want to look, please, at the CTCO and CTCO supervisors policy guidance, CTPHQ 4034, please. So the Case Officer Guide is its title, One-Stop Shop for CTCOs and CTCO supervisors. If we look at page 2, could we just have the version history? So again, picking up on your comments earlier, does it look like the way we should read this is that everything until 3.5 publish is an internal draft going through checks, taking on feedback and being produced?
That's my understanding, yes.
And we take it from that it was first published on the 25th of August 2020?
I believe so, yes.
So notably between AR's first and his second and third referrals, yes?
That's correct.
Described as a one-stop shop for CTCO and their supervisors, one just notes, I think, that you'll be familiar that this is 170 pages long and 13 annexes within that. What's your reflection on that?
So this is a guidance document to support practitioners. It sits beneath the overarching policy documents, which are shorter and describe that high-level process. Its aim is to help and support them with what are very complex and difficult decisions. It wouldn't necessarily be something they'd be looking at every single day, but it means they've got sufficient granular information to help them work through something that's specifically tricky. It's a toolkit, effectively, to help them.
So a manual would, again, I just wanted to understand a bit of reality about this. Would it be fair that this is a bit of a manual that they might turn to quite often in their early months for guidance?
I would have thought so. It would depend on the individual's sort of knowledge, confidence. It would be different for each individual, I think it's fair to say.
And potentially, again, allowing for individuals working in different ways, but if you had a difficult case, a good thing to refer to.
It would certainly help, as would a number of the other policy and guidance documents.
The fact that it took 2 years and I think 3 months from first inception to publication, can we draw anything from that?
I mean, I think it's probably reflective of the complexity and the desire to try and have everything in one document, so that there is a one-stop shop. That will often mean that if something new emerges, they would then pause and add it in. Clearly, you have to get to an end point where then you stop and you publish.
Thank you. And without going through contents pages to prove a negative, I think you'll be able to confirm that at this stage, there was no policy guidance or specific provision about repeat referrals.
There was no specific policy, that's correct.
So there, the standard threshold, the suspicion threshold, a reasonable suspicion threshold would be applied. but nothing over and above that emphasised about the need for particular care with repeat referrals.
Not specifically referenced, but the expectation is that a CTCO looks at all of the breadth of information, and that includes checking systems for not just prevent systems, but policing systems to understand the totality of an individual and consider the holistic and cumulative risks that present.
Thank you. If we just look at page 38 to deal with one matter, in relation to conducting the PGA stage, I think in relation to visits, the general guidance was that it wouldn't be normally necessary to conduct a visit ahead of a PGA assessment.
That's correct, because it's an initial triage and an initial assessment, but the policy does allow that if one is felt necessary, with supervisor's support, it could be conducted.
Thank you. So if we see right at the bottom of the page, relevant exceptional circumstances.
Yes.
That must be enlarged. May be appropriate if there's a suspected immediate risk to life or limb or another very urgent or acute safeguarding risk. Given as an example, although in these circumstances, consideration should first be given to whether the subject needs to be referred with urgency out of prevent into another. I think we just go over the page. Unit or agency. There's also reference to B. The CTCO and CTCO supervisor may feel that there is really not enough detail to make an assessment, but something in the referral raises their concerns, and that not contact the subject risks losing contact with the subject completely. So some exceptions to that, but generally a visit wouldn't be expected before the PGA stage.
Generally, no. I am conscious, I believe in this case, I think it was set as an action from the strategy meeting, so clearly there was a wider context that the CTCO needed to consider. Thank you.
Page 24, please, within this document. If we look at the foot of the page, this is all in a list of what the CTCO should be looking out for. So one sees 6, prevent relevance. All right, so I'm just going to the foot of the page so that you have the header for context. If we go over the page and go to, that's fine as it is, thank you, Sarah. If we can focus on 8, someone who seems to be obsessed with or who has apparently fantasized about committing murder or mass murders like school massacres, rampages, shooting attacks or similar. And then this is particularly concerning if they have also made notes, drawn up a hit list or diagrams of attack plans, even if on the face of these lists seems sketchy or juvenile, and even if on the face of it the person concerned does not appear physically capable of acting on those lists or plans. And 2, within subparagraph 8, for prevent what a subject believes they are capable of is just as relevant as what we perceive them to be physically capable. So that was, would you agree, giving detail about that type of interest in violence falling within what prevent officers should be looking out for?
Yes, it's flagging it as something they need to consider as part of their risk assessments.
Thank you. And then just so that we don't overlook it, if we can just scroll down a little bit to have 10, 11 and 12 on the page. So bottom 2/3. Someone who owns illegal offensive weapons, some kinds of bladed weapons were included within that, or who tries to acquire any weapons illegally online was being flagged. I'm not going to read out all the detail, but that was certainly something to be looked out for. Would you agree?
Correct.
And 11, someone who carries any sort of weapon illegally, even if the ownership of the weapon is legal in itself within the UK, could be on the street, in an educational establishment, or in any public space. Yes?
Yes.
And 12, someone who intentionally seeks out or shares real beheading, murder, or torture videos, particularly if they are also religious, political, or racially hate-based connected videos. But also guidance that this can include other extremist, terrorist, or egregious and graphic or real violent content, particularly if this material has not been produced by a lawful news media outlet. And repeated, very gory, degloving injuries, would you agree that that would come within 12?
Yes.
And thank you. And if we go to the next page, please. And paragraph 7, right at the end, in bold, any combination of the above factors and indicators should be considered, guidance words, very strongly as a potential prevent referral after deconfliction with a FIMU to ascertain pursue relevance. Do you agree all of that was clear in the CTCO guidance, at least in the August version?
Clear in the guidance that they need to consider all of those factors, absolutely.
Yeah, and it's not just clear in the guidance that they need to consider all of those factors. The wording is considered very strongly as a potential prevent referral. It's also, if there's a combination of those, it's looking towards referral. They are due very strong consideration.
That's what the policy asks people to consider. Clearly, the job of the CTCO then is to take into account the context and balance all of that information and make their decision.
Thank you. Turning then to the role of ideology within Prevent, and I'm obviously concentrating on 2019 to 2021. Within this same document, can we go to page 104, please? I appreciate that these are documents from before your time, and you're
fine, I'm familiar with them.
You're familiar with them. And could we look at subparagraph 3, please? So under notes. I'm just going to give you a moment to refresh your memory from that rather than reading it all out. So would you agree that the content there is probably directly reflecting and intended to reflect the messaging that had gone out in the joint letter in the summer of 2019?
In part, yes. It's referring there to TACT as in the legislation.
Yep.
And what that says. But actually, and I wouldn't know the page, I think in other parts of this document, it also refers more broadly to the fact that a specific ideology is not required for Prevent. So it's part of that explanation of not being ideologically focused and considering a wide range of factors.
So the definition of TACT, I entirely understand why you draw attention to that. But the reference to the fact that TACT doesn't stipulate that you have to have a long-standing or deep-seated or fanatical belief, and that people can support or enact TACT offences without a clear understanding of the ideology, and the reference that individuals whose ideological motivations are unclear, mixed or unstable, but who still demonstrate a connection to or personal interest in extremism, terrorism or mass murder, should be given the same consideration for support and intervention as those whose concerning ideological motivations are more consistent and obvious. That distinctly resonates with that earlier 2019 letter. Would you agree?
It does, yes.
And if we look at the letter, CTP HQ 4034, so that's how it seems to get, CTP HQ 30134, CTP HQ 30134. Having looked at how it got translated to the CTCO manual, from the CTP HQ perspective, because we can see that the joint signatory to this was Chief Superintendent Adams. the then National Coordinator for Prevent at CTPHQ. What was the context that led to this letter from CTPHQ's point of view?
My understanding from speaking to the headquarters team is that there were a number of drivers. We were receiving feedback from within the network, so from our practitioners, that they were starting to see mentions and interest in school massacres, school-style shootings as were prevalent in the United States, and that was becoming something that they were coming across. Now, whilst all of the policy and the DIF that was in process at that time had references to, I believe, school shootings and mass killings at that point, there was a recognition that we wanted to, I suppose, highlight and reinforce that part of the existing policies and bring them to people's attentions. This occurred at the same time as some of the work on mixed, unclear and unstable was developing, and you heard from my Home Office colleague, they were obviously concerned in that area. So the intersection was there, and coupled together, it was felt that it was appropriate to draw people's attention to this, to ensure that they were clear that from a strategic point of view, that was something that should be considered as part of present considerations.
Thank you. So if we look at page 2, and I think we find it most helpfully really in the 4th bullet point, so if we can have the top third of the page. We've seen many and similar and often overlapping prevent case examples, including individuals who may be vulnerable to being drawn into terrorism out of a sense of duty or a desire for belonging rather than out of any strong held beliefs. That's the final one. And the 4th one, are obsessed with massacre or extreme or mass violence without specifically targeting at a particular group. So on any view, it's drawing more attention to that subset. Would you agree?
It is, yes.
And on page 4, the 5th bullet point there, I read the 5th bullet point out earlier and I should have done the 4th, but here it is the 5th. Consider the possibility of an individual's obsessive interest in public massacres of any kind as a possible signal of vulnerability. Yeah? So again, the same point being re-emphasised.
That's correct.
As we know, though, the letter at the same time was emphasising that there was no change in the definition of terrorism and no expansion of the role of prevent. Are you familiar with that as part of this letter?
I'm familiar with the paragraph, yes.
Again, appreciating that your post came later from May 24 onwards. Looking back at this now, do you recognise a risk that this letter was trying to, as it were, ride two horses?
I understand that point. My interpretation of that paragraph, and clearly I wasn't the author of the letter, was to, I believe, to highlight that there wasn't a change in the legislation. So clearly Section 36 is a legislative point in the duty about that decision of reasonable grounds to believe that people are susceptible to being drawn into terrorism. So that's how I personally interpreted it, was that people absolutely must consider these as factors as part of their considerations, but it was highlighting to people, because often what we will get asked is, does that mean the duties changed?
Yeah.
And that's how I interpreted that paragraph. So rather than perhaps driving two horses, just giving that clarity. But I may be mistaken, because that was just my view on reading it.
The emphasis, that in one sense may be understandable, but that emphasis on no change in the definition of terrorism or the remit of prevent, that brings back into play the definition of terrorism in the Terrorism Act and the need for it to have an ideological cause.
To some degree, but we then come back to the pursue and the prevent differences. The prevent test is much further upstream and isn't specific to the Section 1 definition, in the sense we are talking about being susceptible, vulnerable to radicalisation, not meeting the legal definition for a pursue sense. So I do understand the point, but the letter was sent to prevent practitioners working within the context of Prevent.
Thank you. Can we just go back to the first page of the letter, please? Looking at the date of the letter of June 2019, and bearing in mind how this entered into the CTCO guide, which was August 2020, of obvious interest to us is the fact that AR's first referral came between those two dates. Other than the letter itself, which you would have expected to be cascaded, can you give us the general picture of what was done to drive home these messages and to avoid any confusion in terms of CTPHQ between the summer of 2019 and when it came out in the first edition of the CTCA guide?
So my understanding is that the regional Prevent coordinators would have disseminated this through to their teams. I would stress this wasn't a new policy position, so the DIF that was in existence at the point of this letter and prior to it featured the categories and the detail around school shootings and massacres. So this was really just reaffirming and highlighting something that was already present within policy. So I haven't got records of exactly how it was communicated out by each teams, but my understanding is that it was built into training, but these factors were already within the training because it was something that existed in considerations for CTCOs anyway. The letter was really just re-highlighting something that was already in existence.
The DIF 2019?
Yes, the DIF, and it was utilised, I believe, there was a DIF created for the first referral, as I understand it.
Just keep your voice.
Apologies, someone may correct me if I'm wrong, but I understand there was a DIF utilised in the first referral and that it was in place in 2019.
Right. At times you're slightly softly spoken, and you're also making the mistake in courtesy of turning towards the chair, and to me, it's the two mics in front. Just keep your voice up just a little. So CTPHQ 30110. I promised that I would come to the DIF. CTPHQ 30110. Thank you. So, slightly difficult document on our screens, but before we leave the first page and go to the passage that I think you have in mind, can we just note that whereas the earlier document that we were looking at was indicating, we have the top quarter of the page, including the header highlighted, please, Sarah. Whereas the earlier document that we were looking at was suggesting that the DIF was for something after the PGA. Here, consistent with what you said, the dynamic investigation framework is headed as being for Prevent Gateway assessments and to support PLP case management plans, yes?
That's my understanding, yes.
Again, that's something that if the DIF was meant to be used for Prevent Gateway assessments, should have been absolutely clear, shouldn't it?
Yes, I believe it was. It's, again, the sequencing of how updates have gone out to the team. So I wasn't present at the time, but I am assured that the DIF, it was known and the DIF was utilised for the Prevent Gateway assessment.
Thank you.
I will check my records, and if I'm correct, I will come back to the chair and correct, but I believe the DIF was used for the first referral.
Understood. And then you've said a number of times this was something that was in existing policy, and it may be that what you had in mind was at page 6. If we can go to X under 5, so ideology, it's paragraph 5X. Sorry, the print is very small until it's enlarged. So under ideology, you're meant to describe any hateful or extremist causes, ideas or beliefs, etc. And then 10, within the list, a concerning fascination with extreme violence or the tactics of terrorism, mass casualty attacks or school massacres per se, even in the absence of a unifying ideology or narrative reason for this interest, may also be indicative of a subject who requires support through PREVENT. Context needs to be explored around this interest. An obsession like this, combined with complex needs or grievances, might be suggestive of a higher risk subject. Explore and explain circumstances, yes?
That was certainly one of the references I was highlighting.
Thank you. Resonating with AR.
Yes.
Thank you. That can come down from the screen, please. I want to turn next to the intersection between PREVENT and mental health and neurodivergent conditions. Could we go back to CTPHQ 4034, please? Start again with page 1. All right, just again, because I'm jumping from document to document quite a lot, so we're back with the one-stop shop for CTCAs. And can we go to page 87, please? While we've got it on full screen, do you see that this is Annex 1 completing the diff? Yeah.
Yes.
And on the basis of the evidence that you've already given, we should be here thinking about the diff being something that should be completed ahead of the PGA.
As part of it.
As part of the PGA.
Rather than ahead of it.
Yeah. So if we can then have the bottom half of the screen, complex needs and vulnerabilities flagged. So within this, certainly in this, its first edition in August 2020, do we see under complex needs and vulnerabilities, paragraph 1A1, mental health issues, mental ill health and disorders can increase an individual's vulnerability towards being targeted by groomers or being coerced towards terrorism offences, or in some contexts, self-radicalised towards extremism. And it would appear as a result of that, it goes on to say, identifying mental health issues is crucial to planning successful support and intervention plans, yes?
That's correct.
And so, as several witnesses have touched upon, I'm sure you'd agree that it requires a careful individual analysis as to what the mental health conditions are and how they're affecting the individual to assess whether they might be within the category of individuals for whom a mental ill health or a mental health disorder could, in effect, increase the risk of being susceptible to radicalisation.
I think, as stated further down in the document, those factors can be an increase in risk, they can be a protective factor. Your point around exploring and understanding the nuance for an individual is critical.
So is the answer to my question yes?
That it should be considered, I think.
Yes. It needs a careful analysis of the individuals, because I don't want to generalise, it's not going to be mental health condition equals increased risk, but it needs to be carefully analysed for the individual to see whether they fall into the cohort of those for whom a mental health condition may increase the risk.
That's correct.
Is that fair? Yeah. And specifically, you were rightly reading ahead further down the page, we see in relation to A2 subparagraph 1, autistic spectrum disorders, that research around radicalised people with ASD, particularly by the Radicalisation Awareness Network, discovered that certain characteristics can make people with ASD more vulnerable to radicalisation and violent extremism in the, in quotes, right context. I think in quotes because in a sense it's the wrong context, but we follow what's meant. For example, they may be deliberately targeted and influenced by recruiters, etc., or they may have other vulnerabilities and grievances connected to the condition in their context. So just pausing there, I'm not ignoring what comes after, because I'm going to come back to it. But sticking with my phrase, risk concern cohort within autistic spectrum disorder, that's flagging two things. One is potential susceptibility to recruiters or groomers taking advantage of the autism.
That is possible, yes.
But it's also flagging that those with autism spectrum disorders may have other vulnerabilities and grievances connected to the condition, which may mean that they're more susceptible to radicalization or self-radicalization.
So this section is highlighting, as you say, the need to consider all of those details as part of the risk assessment, but equally not to make an assumption that somebody with any of these conditions
quite wrong.
is therefore, that is quite wrong.
There's no dispute about that. Nobody's suggesting autism equals increased risk, and I'm not suggesting it, which is why I said I'd come back to the second part. However, traits of ASD can be either a risk or a protective factor, depending on the individual and their unique circumstances. Yes?
That's correct.
So considering which traits are more prominent in the individual will assist the CTCO in making a more accurate assessment and effective case management plan. Yes?
Yes.
And so what you would expect is not an assessment which in effect says this behavior can be put down to autistic traits. You would expect an analysis of whether the individual, with their individual mental health conditions and how it is affecting them, whether they come within a cohort where that might increase the risk or may even be a protective factor.
That needs to be balanced and considered, yes.
And how do you get that assistance?
So the Vulnerability Support Hub was one of the options, as could be seeking further information from partners who are involved in the case. You could gather from a number of different places, but at that time, the Vulnerability Support Hub was one of those options as referenced in the policy. And
in light of the questions and answers that we had with DCS Ken Wright yesterday, in fact, the guidance is absolutely clear at this stage in August 2020 at least. Hence the need for more expert input from the vulnerability support hubs. Yes?
Yes.
That is the diametric opposite from the person who's being referred is getting assistance with mental health through the outside mental health providers. It is looking at the prevent availability of vulnerability support hubs to give expert input to help analyse the risk of harm to others.
So the Vulnerability Support Hub can do a number of things. It can help give expert advice to inform risk assessment or plans.
Forgive me. I'm focus on the aspect that I'm asking about because we appreciate it can do other things. But in this context, the guidance is encouraging the Vulnerability Support Hub to be used to assess whether somebody with autism spectrum disorder is likely to be within the cohort of those who may have increased risk.
It is.
And you would expect that to be followed?
Yes.
Thank you. We just go through, please, to the very bottom of the page. Can we just go over the page? Thank you. So for your note, Mr. Goss rightly reminds me that CTPHQ 30/110 gives for the diff for 2019 the equivalent.
Thank you very much.
Thank you. Can we turn to the role of open source? That can be taken from the screen. The role of open source intelligence, internet and device investigations. At the stage of an analysis by a CTCO leading to the PGA, what was the general expectation in terms of the open source social media and internet use checks that you would expect to be done?
So I believe at that time, certainly of the first referral, it was referenced in the 2018 policy as something to be conducted at the PGA stage. On occasion, it may be conducted by the FIMU if there was something in a referral that they felt needed that check, and then clearly a CTCO wouldn't repeat that check because that would be not necessary and proportionate. But I believe it was referenced in the 2018 policy, but not in any more specific or granular detail than flagging the need for open source checks.
Thank you. Could we look at CTPHQ 4034 again? So back in the one-stop shop, August 2020 version, at page 94, could we have the middle of the page expanded, please, Sarah? Thank you very much. The internet and social media leakage. There's quite a long list there, which I won't read out, of what to consider, but potentially quite extensive list of things to be on the lookout for based on, it's referred to as internet and social media leakage, but presumably one should understand that as what might be capable of being viewed from open source.
I believe so, yes.
In terms of where responsibility for this lay, you mentioned, I think, that even in previous guidance this had been flagged up and that it might be conducted by the FIMU. Was there a clear understanding of what the responsibilities were between the FIMU and the CTCO as who should be conducting this sort of check to look for this sort of material?
So open source as a term was specifically referenced in the 2018 CTCO guidance. As I say, a FIMU may have, it would depend on the content of the referral. If that was an inquiry they needed to conduct to make their pursue assessment, then clearly I would expect them to conduct that. But in the terms of then the CTCO's role, it is referenced in guidance.
So if we could look at CTPNW 4088, please. Could we start, Sarah, just on the front page? You see that this is a historic case review by, I think, the Deputy Regional Prevent Coordinator for CTP Northwest. If we go to page 2, we'll see what it's a historic case review about. So as a result of the dreadful murders that we're dealing with, there was the commissioning in CTP Northwest of a review of CTP Northwest prevent cases recorded between July 23 and July 24, which have been closed where either school massacre or fascination with extreme violence was the subject matter. Do you see that there?
I can see that, yes.
And then if we go to page 5, we see that in the assessment that CTPNW did as to compliance with national policy, that some 17 cases were found, original emphasis not underlined, to have complied with national policy, so just over half. Do you see that there?
I do, yes.
And then missing III accounted for the majority of these cases being present in 15 of the 17. Yeah, and that's the acronym for the Internet Intelligence Assessment Investigation. The 3 Eyes policy was officially published on the 21st of October 2022, but its distribution was limited to an email to RPCs. CTPHQ have accepted that the policy was not then integrated into national prevent policy or guidance, nor any of the mandatory prevent training courses. As a result, CTP-NW were not aware of its existence until CTP-HQ conducted a business assurance visit in November 2024, finding 3I's missing in their reviews. It was fully expected, therefore, that this review would find the same. That does not appear to be describing a happy state of affairs.
It's certainly describing gaps in the awareness of the 2022 policy and was also highlighted in, I believe, either the PLR or both the PLR and the Dignate review, and there is currently ongoing work to review that 2022 policy and ensure that there is absolute clarity on that position across the network.
And in fairness to CTP-HQ, it seems to reflect that it had been distributed in the sense of an email going to RPCs, but that seems to be describing an ineffective carrying through of policy into what the regions should actually be doing. So an email goes out with a policy, but it doesn't then get replicated in national prevent policy and guidance. And indeed, CTP-NW seem effectively to have been almost unaware of it.
So the policy was a separate policy. As is often the case, we will circulate separate policies, and then when we review the policy as a whole, we'll condense it into the one overarching document. Similar is the case for the repeat referrals policy. They are separate and will be then added into the broader policy document when it is reviewed as a whole. I'm not aware of the detail of exactly what instruction was sent to the RPCs, but obviously this confirms an email was, nor am I aware as to why then they wouldn't have circulated, but it certainly highlights that that process hasn't been successful from the findings of this.
And coming back almost to where we started, do you remember, Deputy Assistant Commissioner, that I asked you about your in-tray and your top priorities when you came in? And one of the two things that you asked to be, to the Chair to be aware of was the effect of the internet and how pervasive it is. And so the 3I's checks and doing work on open source material is pretty fundamental, isn't it?
It is, and as we say, there was a policy that gave guidance on that. The business assurance that is referred to there is a product that I commissioned following the PLR and the findings to ensure that we understood what our current position was in the network around a number of different themes and concerns that were found across the reviews, to then ensure that action was taken to resolve those.
As the SNC, if you were to go out tomorrow and do a spot check in any of the regional CTUs to check whether proper 3I's checks had been done, what would be your confidence level that it had been done?
I am aware from conversations I've had with regional prevent coordinators and CTPHQ that III policy is something that is far more actively in discussion and aware of. I wouldn't like to speculate as to percentage. That's why we will continue to conduct business assurance to check the effectiveness of those processes, but it is certainly something that I would expect the awareness to be higher.
Thank you. If we can go back, please, to CTPHQ 4034. Turning away from how embedded the policy has been and how understood it has been. So CTPHQ 4034, and back on page 94, please, Sarah. If we look back at the list in the middle of the page, please. Plainly, in a prevent case that goes through to consideration for channel and is adopted, where consent is given and the subject is a child, as we've explored with other witnesses, that there may be work that can be done both with schools and with family members to review social media and internet use in the home and at school?
Certainly, if permission is given, that is
So
definitely...
assume that consent is given.
That is definitely an option, as is some of the sort of cyber awareness type products that Home Office colleagues referred to.
So, and work done with the subject of the referral himself or herself in terms of education about risks, but also a degree of monitoring by consent could be achieved within a prevent referral that's taken on.
It's an option that could be considered.
If consent is not provided, and if there is no police power because of a criminal investigation that is ongoing, so you don't have the devices seized because of a criminal investigation, getting an understanding and a prevent referral of these sort of items at B is extremely challenging, isn't it? You can get open source checks, but what they're doing beyond what can be visible on open source is going to be very challenging in the absence of consent.
So prevent is not an investigation tool that would be pursued, so we are confined by the powers and obviously taking into account people's human rights and all of the complexities of the legislation. So in prevent, consent would be the route to understand that.
Yeah. You're getting somewhat ahead, if you don't mind me saying so.
Sorry, my apologies.
What I'm interested in is the difficulty of making an assessment of these items in B in the absence of consent. I mean, that's going to be a real challenge if all you can see is open social media accounts.
I think this and a number of other areas we've touched on goes to the heart of the very difficult decisions CTCOs have to make.
All right. Appreciating that these are ultimately political matters, but can I seek your views as to whether there should be a specific power to aid CTCOs and the prevent process so that they can see non-open source internet use, specifically in the case of children?
I think obviously from a policing point of view, we utilise the powers in the legislation that's available to us. I would say it is always better for us to have as much information as possible to properly assess the risk, and anything that helps us to do that is clearly preferable. But any powers that then lead us to look at content need to be balanced very carefully with people's necessity, proportion, and
civil liberties and human rights
it's,
considerations.
It's a very fine balance, and probably not one that policing should make any decisions on. We would obviously utilise any powers.
I've made clear it's not for you to make the decision, but respectfully, what you can assist the chair with is how much of a problem, a disadvantage, a challenge is it? And that's why I was asking you, it's going to be very challenging for the CTCO to get an understanding of this in the absence of consent. So how much of a handicap to the work of prevent is it that at the PGA stage you might have very little visibility of what a child is doing online because you haven't yet got to the stage of deciding whether to take them on, and you don't yet know whether consent is going to be forthcoming. Just in terms of how much of a problem this is to making reliable assessments.
More information in this space would definitely be helpful, but it is normally one of many factors. So there are normally other things that you can take to then help your decision to decide whether a case needs to go through or not. But if there is information that we can't see that contains risk, then we can only make decisions on what we have. So more information is always helpful.
All right. And in the cases that do get through this threshold and are taken on, but where consent is not forthcoming, and you get into a police-led process, don't go into operational details that wouldn't be appropriate. But is there a challenge there also, if you're in the police-led process, on getting visibility of online, non-open activity by children?
Clearly, a police-led case is one of the factors is not having consent. So the same applies to whether you have consent in the prevent space or in the police-led space.
So a hindrance on mitigating risk in police-led cases like that? And if so, to what extent?
The same considerations, whether it's in the police-led space or the prevent. So it's the same as I described for the prevent space, I would suggest.
Thank you. Perhaps with this addition that the very withholding of consent might be an additional concern that would lead you to really want to be able to see what they might be doing online.
I think clearly we would like anybody that's referred into prevent to have consent from parents or adults. There's a number of factors as to why people will choose not to give consent. So
You can't go further.
I wouldn't like to speculate.
Thank you. I'm going to move away from that topic and just look very briefly at some other limitations on prevent. And I'm asked to explore with you just the issue of resourcing, which I'll do briefly. I said that I would come back to how demanding the role of the CTCO is. Would you agree that in general terms it requires officers with good skills and dedication because it is a demanding role?
Absolutely.
Obviously, carrying a caseload, both of doing assessments, but of also then involvement in cases that have been taken on. Yes, the CTCO is not just making assessments, they're also dealing with the multi-agency interventions at a later stage.
They are, yes.
Can you give us a broad understanding of how that reflects in terms of resourcing, so retaining CTCOs, the difficulty of recruiting them to the role, difficulties of getting staff of the right calibre? What are your impressions in that area?
So we are able to recruit and retain staff in prevent. I mean, clearly it is a very difficult and high-pressured environment, but the staff are very committed to it. I liken it to any roles where similar decisions are made in safeguarding, where people are having to balance very difficult, complex risks assessments coupled with vulnerability, but ultimately their desire is to protect the public and make the right decisions. So we are able to recruit staff. The challenges will look different in different regions depending on the sort of forces that are made up in those areas. So it's difficult to give a one assessment for the whole network. I think there is a reality that our officers and staff absolutely understand the importance of the decisions they make when they consider these cases.
Nationally, are the roles full, or are there gaps and vacancies beyond the natural short-term vacancies?
I believe predominantly we're only in the sort of natural range of vacancies, but that will vary from region to region.
And obviously, as we heard in relation to PC Thompson herself, who left on promotion to sergeant, there will be a natural rotation as officers progress their careers. But is there any particular problem with churn, with people leaving sooner than one might have expected in this sort of role?
I'm afraid I don't have that specific detail to hand to answer that now. I can obviously respond in writing to the inquiry in more specifics. There will always be churn. Some people, we will have individuals who leave because perhaps the role isn't for them or the pressures of role, but equally we have some people who have been in prevent for many years. It varies from individual to individual.
But as you sit there now in your SNC role, that's not an item that you know is on your significant worry list in terms of there's a particular problem with retention or churn for CTCAs in particular?
It's something we keep a very careful eye on, particularly given the demands of the role, the increases in volume, and, as I say, the complexity of the role. So it's something I am very minded to ensure that the CT heads are supported with.
Thank you. Can I turn to a different topic now, CTPHQ role in relation to AR? We've dealt with the fact, I think, that there was no involvement of CTPHQ in the referrals themselves. After the attack, you deal with this in your statement, but it's right, isn't it, that there was never a declaration that this was a terrorist incident?
That's correct. This was not declared a terrorist incident.
And DCI Pye from Merseyside Police explained in his evidence that this was because there was no evidence that AR engaged in his awful acts of violence to advance a political, religious, racial or ideological cause. Is that right?
That's correct.
Whose role is it to actually make that determination whether to declare it a terrorist incident or not?
It's my role.
And no doubt, that being the case, you would have been kept carefully informed, yes, of the developments in the investigation in AR's case.
Absolutely. We work very closely with Merseyside Police throughout.
And being kept carefully informed of all of the investigations, both counter-terrorism and policing, is it right that there was never a stage reached when there was evidence of that terrorist type of ideology for AR?
There was no evidence found to show or suggest that the attack was, as you say, motivated to advance a political, racial, religious or ideological cause. What I would say to that is I completely appreciate for the survivors, the communities, that doesn't in any way lessen the horrificness
doesn't change
of the
the trauma or
absolutely
the
not.
awful level of violence, but from a
technical point around a definition, not a reflection of the horror that his acts caused.
And it may be helpful in that context for you just to help to explain why the findings of the academic paper that contained the Al-Qaeda training manual, why that didn't change that assessment. Can you just explain that?
Absolutely. So the Section 58 offence, which is effectively possession of that material, doesn't require that motive. It is a liability offence. You are in possession of something that could be useful. The evidential assessment, which was carefully thought through by Merseyside and our teams, was that that document may have aided the methodology utilised, the mechanics of the attack. Forgive me for using that phrase, but it didn't, nor did any other evidence show that the motivation of the attack met the Section 1 definition.
Yes. And none of my questions, just as none of your answers, are designed in any way to diminish the awfulness of what happened. But it's important that we just explore, and that I explore with you as the head of counter-terrorism policing headquarters in this area, and as the person who would have made the judgment call. It's just important that I explore these aspects with you.
In very simple terms, we never identified the why.
Yeah. And the holding of an Al-Qaeda training manual, and you use the words carefully about informing the mechanics of the attack. Should we understand that the assessment was that dreadfully and shamefully that fitted in with AR's fascination with extreme violence, and when seen as a whole, there was not an indication that he was holding that manual because he had, for example, an Islamist extremist agenda?
That's correct. I don't believe, and our assessment was that it was in relation to that violence, fascination, and that was in keeping with the other horrific content that was found during the investigation, and not an ideological motivation.
Thank you. And we dealt with this with DCI Pi, but it was some time ago. I think you'll be aware in broad terms that what you rightly describe as the other horrific content that was found during the investigation included content that would be grossly offensive to Muslims.
Absolutely. There was content that would be grossly offensive to many different communities and the public more broadly.
Thank you. Thank you. Can I turn away from that important topic and look at changes made since? This is a change not since the attack, but between AR's referral and the attacks, and we've referred to Sir William Shawcross's review. Could we just have a look at that, please? HOM 4071. So this is 2023 review. And may we just please, Sarah, within this, look at page 56 and 4.57. And for reasons of time, I may be at risk of oversimplifying this, but if we look at paragraph 4.57, Sir William said this: inevitably then, I'm forced to raise the question of whether it makes sense to refer to prevent individuals who have no clear ideology, given that acts of violence committed by such people would not be regarded as terrorist in nature. Reflecting on Prevent's referral data for the year 2020 to 2021, Home Office analysts cautioned against reading too much into the data, showing large numbers of MUU referrals. They pointed out that it could be that practitioners are now classifying as MUU cases that previously would have been identified with other specific ideologies, such as Islamist. And if we could look, please, secondly at page 66, at paragraph 4.106, Sir William was noting here that local practitioners claimed that there was sometimes a lack of suitable services available, such as ADHD clinics, Asperger's clinics, and behavioural clinics, or general support for those with learning difficulties. I was further informed that children with autism were being processed through the channel system when they ought to have been supported with more appropriately by alternative services. Now, those two passages, which I may be at risk of eliding, but they do seem, reading them now, to be somewhat pulling in a slightly different direction from the joint letter, which had flagged up the importance of this type of ideology, and from some of the guidance that we've seen in relation to the importance of looking at autism. Do you see the potential for that tension?
I do see the potential. As I highlighted earlier, our indicators and risk factors didn't change in respect as we still saw those things as factors that needed to be very carefully considered by CTCOs. Your point in relation to mixed, unclear and unstable, I referred to earlier around part of the reason we removed that terminology, because people's understanding of what they categorised as mixed, unclear and unstable could be differently interpreted and confused. Therefore, we removed that terminology and asked our practitioners to be more flexible, and the tools were more flexible so they could highlight all of the things that may be evident in a case, and that may include multiple ideologies, it may include no ideology, but other risk factors and vulnerabilities, to allow that flexibility so their decision-making wasn't hindered by references to that as a category.
But acting on this report, if we go back to the Prevent Duty guidance, the updated post-Shawcross version at CTPHQ 4012, please. Page 12. paragraph 34. So picking up halfway through, prevent activity across all extremist ideologies and radicalisation concerns. Where frontline professionals have identified a concern that they consider requires a referral into prevent, it is important that they can indicate why this risk is relevant to prevent. As prevent is a counter-terrorism capability, the presence or possible presence of any terrorist or terrorism-linked ideology will be an important consideration. Now, in fairness, it's not saying it is essential and there won't be a prevent risk in other cases. But again, do we see here signs of something of a tension which perhaps has not been fully resolved between the post-Shawcross intention of emphasising the importance of terrorist ideology with the aims of the June 2019 letter?
Obviously, at time between June 2019 and 2023, time had passed, and even more so now, another policy. I think the bit I would highlight there is it's talking about prevent activity, looking across all extremist ideologies and radicalisation concerns. And that's what we encourage our practitioners and anybody referring in to consider is it's that susceptibility to radicalisation. Ideology is one factor. It is by no means the only factors. Yes, it's an important consideration because if somebody is already at a point where they are showing a strong leaning to an ideology, that is something that would definitely be important and require consideration, but so do all of the other factors that potentially give us information to assess that susceptibility to radicalisation. Obviously, this is a Home Office document and they have updated their Home Office policies as a result of that review, and it hasn't, I believe, been updated since that point.
Rolling forwards to the current time, you mentioned earlier in your evidence, and I think again I promised to come back to it, the Prevent Assessment Framework, the PAF. And for practitioners, as we've understood it, the PAF is now used as a common tool at the different stages, including at the PGA stage.
That's correct, yes.
And I won't repeat matters that I dealt with Ms. Elsmore yesterday, but is it right that the training that you mentioned in relation to the PAF has been rolled out so that all CTCAs will have received it?
The PAF is an accredited tool, so without having completed the training, which is pass or fail, you cannot use the tool.
It has that advantage of being a single assessment rather than multiple different assessments at different threshold stages. I think in particular, so again, this is one for your note and not for bringing up on screen, CTPHQ 30127, so not for the screen, but for the Chair's note, please.
Thank you.
That there are indicators of concern that are quite specifically set out within the PAF. I think you'll be familiar with them.
There are specific indicators for people to consider, yes, and it provides a flexible framework to support CTCO decision making.
And would this be fair, more directional than previous tools because they give more specific indications of what to look for, and there's a more directional requirement to record things under certain headings?
I would hesitate to say directional. It gives them a very firm structure to work through to record their considerations and their decision making. I think we're talking about the same thing. The structure requires
it's a structured
decision making.
Attention to, that's really what I was meaning, that the structure requires their attention. It's directional in that sense, that there is a specific structure that requires the CTCO to work through a list. And it's not a sort of tick box exercise. You've got to do the analysis under each of those headings.
It definitely helps them guide through that analysis. The decision is still their own. It is a framework to aid those decisions.
Thank you. I'll come back to that just briefly at the end of this section. There's also been a new policy on repeat referrals, CTPHQ 4010, please. So if we just go to page 2. So addendum to policy and guidance, multiple referrals, risks, supervisions, accountability. Again, I know you'll be familiar with this. But page 5, message from the SNC?
From me.
From you, yeah. 2023 addendum came as a result of increased learning from academia, feedback from intelligence colleagues, finding from business assurance processes, and recent prevent learning reviews. And then in bold, the addendum highlighted the cumulative risk that multiple referrals, defined as 2 or more referrals, can pose within our casework. Yes?
Yes.
And this flags up again in bold, does it not, in the message from you, that multiple prevent referrals is itself a risk factor that must be considered.
That's correct.
The multiple referrals here, to try to deal with the technicality, that wouldn't include, would it, 2 agencies reporting at about the same time about the same risk. It's more about at different stages in relation to different events or different concerns?
Well, you'd expect all of that to be considered. If 2 agencies referred at a very similar time, it's likely that those would be pulled into one assessment, therefore would be a single record. So if they were very close together, it would be dealt with because it would form part of the assessment.
Yeah.
But ultimately, the expectation and requirement is that the CTCOs look across any referrals that have come in and use all of that information to then inform decision making.
Thank you. It's not strictly a question about repeat referrals, but just in general terms, does the identity of the agency making the referral make a difference? Are police referrals given more weight than school referrals, or?
Absolutely not. If anything, and I think my Home Office colleague, Catherine, touched on it, family members, when they refer in, because they are the people who are closest to individuals, and it can take an awful lot of courage for a family member to report a concern of this nature in. It's not that they're given more weight, but clearly we recognise that that is a very significant thing for somebody to do. But every referral, irrespective of where it comes from, is judged on its merit. No agency or even family members are given more weight. We consider the content.
Thank you. So back on this particular subject, if we could look at page 8, please. Detail is in your statement, and Ms. Elsmore has dealt with it as well. But if we go to page 8, we see the enhanced oversight for multiple referral cases. Can you just give us the thumbnail of what the enhanced oversight now is?
So the enhanced oversight is that an inspector must be informed when a case comes in, so that they then review the referrals, and then similarly there is that the inspector should have an oversight of the case management, and also then they would be part of that closure. It highlights there the regional prevent coordinator must be cited if there are multiple referral cases that have not been referred into channel or PLP. So effectively, if a multiple referral case doesn't meet the Section 36 decision for reasonable grounds to believe, we ask that those cases are highlighted to a regional prevent coordinator, so the person within the regional who's got that operational oversight, so that they can reassure themselves that the reason for that decision making is appropriate and proper.
Okay, so that's going significantly over the sergeant who would be normally expecting to approve that. That's going for a more senior officer.
It is. So there was a repeat referrals policy that predated this, so there was a policy in existence, and I believe from memory that did have inspector oversight in it, but the oversight that is within this current interim policy is even more enhanced.
So we haven't gone to the interim one, but I think as a result of other events there was guidance on this, and this is the further strengthened version.
It is. We are currently in the process of carrying out business assurance to understand that what's the effectiveness of each piece of this policy, and then consider how we include it into the full policy review that's ongoing. But it will include the increased oversight in some way, shape or form.
Thank you. You deal in your statement, that can be taken from the screen, please. You deal in your statement in paragraph 54 with the development of an improved tracker. So I think that the technical name for it is the Prevent Case Management Tracker Enhanced PCMTE. Is that right?
That's correct.
Just give us the thumbnail of that in terms of why that is an improvement.
So it's a far more improved system in that it is electronic. It guides both the CTCO and the supervisor through the processes required. It is a more robust system for tracking the cases through. It has an activity section, so in a similar way to an action tracker, activities can be recorded and the outcome and the rationale for those activities should be recorded. And a case cannot be closed unless each of those activities is resolved with an outcome, and that outcome is justified. It also ensures and pushes through the relevant supervision that's required. It does other things over and above that. It's effectively a far more robust.
So one of the issues that came up yesterday in evidence with DCS Kenwright was whether there ought to be a system whereby if, for example, an action has been set of a referral to the Vulnerability Support Hub and for some reason, human error, it's not been done, that you couldn't actually move to recommendation for closure because there's an outstanding action. Is the tracker enhanced actually designed in that way that you physically can't move to that stage if a referral that's been referred to, which should be an action, hasn't been completed?
Provided the system's been used to record each of those as individual activities that I just referred to, then if those activities remain open, it can't move forward. So it definitely provides a more robust approach to monitoring those activities which are set, and an action would effectively be an activity.
That's dependent upon the CTCO correctly using the system to identify an action point as a formal activity on the system, if I've understood your evidence correctly.
That's correct. I mean, I think that's true of all systems, to be fair. It requires the human input in the system to be used correctly. But having said that, it still guides the supervisor through a more structured review process, so it still provides assurance in that way.
Thank you. Moving on then to improvements and changes in relation to unclear ideology and violence-fascinated individuals. If we can have on screen, please, CTPNW 4016. And if we can just go to page 2, please. Can we identify the document? So, fascination with extreme violence and mass casualty attacks, interim referrals policy. Can you just help us with the interim nature of this policy? Is it going to be made permanent?
So, like the repeat, both of these policies were policies that I commissioned and required to be enacted quickly to ensure that there was absolute clarity for the network as to what was expected of them. They are additions to the broader prevent policy, and my desire would be that all of these things are contained within one policy. As I highlighted with the repeat referrals, it's also necessary to check and test that a policy is working and actually delivering the outcomes we want it to. And currently, these policies are going through business assurance to check that they are actually achieving the outcomes and the aims that we require them to before they are placed into full policy, and we'll make any amendments before that happens.
And how do you know that this is a policy from this year? How do you know that this has actually reached CTCOs and has been embedded in their practice, that they've been trained on it or at least required to read it and say that they've understood it?
So there have been communications both through RPCs and from headquarters. There have been online training sessions. you can imagine this is something that our Prevent workforce absolutely know and understand. And I have, when I've been in regions on visits, spoken to CTCOs and supervisors, I'm confident they know and understand that these policies exist. And clearly, because both this and the repeat referrals have an enhanced level of supervision, there are actually supervisors who, again, are familiar with the policies and provide those checks and balances.
Thank you. We don't need to turn back to it because we'll keep this document on the screen if we may. But in paragraph 60 of your statement, you said this: the 2025 interim policy serves to reiterate the position expressed in the June 2019 joint letter and to provide guidance to practitioners around their decision making when dealing with this cohort of subjects. Now, I'm not going to suggest to you for one moment that this guidance is not consistent with the June 29 policy, but when you say it serves to reiterate the position expressed in the June 2019 guidance, that's a little bit of an understatement, isn't it?
I'm not sure it's an understatement. I believe that policy reaffirms the position in 2019 as set out in the letter. It also reaffirms the position of a number of other minor amendments that have been made around these topics more generally. So I suppose what I'm referring to there is it absolutely reinforces the July letter. It also brings together in one place all of the subject matter that helps people make decisions around these categories of individuals. So,
insofar as this type of policy document ever is, this was an expression of concern from you as the senior national coordinator, wasn't it? An appropriate expression of concern.
It was me wanting to ensure that those practitioners working in Prevent understood all of the parts of policy that had been updated in relation to this matter so that they could make their decisions based on this policy.
Again, if I may say, or if I may suggest, the appropriate message from you, if we look at page 5, what were you seeking to deliver in this message?
Seeking to highlight the importance of the policy, and not only, what I would say is this policy highlights the broader concerns around the change in threat that we have been seeing over a number of years, which has been highlighted to the network through a number of policies, which is we are operating in an environment where violent material, horrific online material can have an impact on our casework, and it really just strengthens the message about the importance of that. Throughout a period of time, we have instigated child-centred policies within CTP. We've referenced in evidence a number of amendments made to policy to highlight all of these concerns. So it's really just a strong message from me to the network of the importance of using all of these tools and these policies appropriately to manage risk, to support the CTCOs in the very difficult decisions they have to make.
If we look, Deputy Assistant Commissioner, please, together at the third paragraph and the fifth line. From the date of this policy, Prevent officers, your words, must treat these referrals with the same level of diligence and risk management as referrals where there are clear concerns with terrorist ideologies.
Yes.
That was not an accidental choice of language on your part, was it?
No, it wasn't. It was to reflect the learning that we had received from Dignate reviews, from business assurance. It was, I suppose it reflects your point around making sure we're clear with practitioners. So my language was intentionally clear to ensure that people understood what this policy was trying to ask them to do.
And it may be an unfair question, and you'd be entitled to say so, given that you've been in post since May 2024. But does it concern you that we are 6 years on from the joint letter, and that as a broad organisation and process, there is still the need within Prevent for the senior national coordinator to be giving a message with this clear and appropriate authority and urgency. Prevent officers must treat these referrals with the same level of diligence, etc. Because one might have hoped that that would have been effected well before now.
I'm not suggesting it hadn't been affected and that those messages hadn't gone out previously. We've referenced various points in policy and training where those messages will have been clearly delivered. But as you would expect, after the reviews that we'd received in such a horrific event as happened in Southport, it's absolutely appropriate that I, in my role as Senior National Coordinator, reaffirm the previous messages. Some of our workforce will not have been within the system when those previous updates were given. We are going back over a 6-year period, so this might be the first time some of our workforce are reading and hearing this because they weren't actually working within Prevent at that time. So this is simply reaffirming all of those positions and ensuring that they know that that is absolutely current, and those are those points.
And I appreciate there's an element of damned if you do, damned if you don't, because if you don't give a clear, strong message, that would be picked up, and I understand that. But do you see the concern that might be raised that this has taken a long time to firmly embed?
I do see the concern that you're flagging, but as I say, this isn't the first time that those categories, they have existed within our policies and process. I'd also flag that when we use the term violence fixated individuals or fascination with extreme violence. The VFI term is one that we have used currently in the past 12, 18 months to describe what we are seeing more broadly in the threat picture. It's something I've referenced publicly. The Director General of MI5 has. We are seeing a different threat picture. Some of those people then are drawn and susceptible into terrorism. Unfortunately, some of them go into other forms of criminality. It's about the broader challenge that we have as a society with some of our children and young people being impacted by lots of influencing factors, including harm online.
Thank you. So for your note, Deputy Assistant Commissioner, could I just invite you to accept that this is what we find in the detail of this, that we see, for example, we don't need to turn these up, but page 6, emphasis on the fact that the absence of a terrorist ideological motivation doesn't appear to reduce the potential risk.
That's correct.
That's highlighted. So for your note, also at page 6, these cases need to be given particularly careful consideration.
Correct.
And page 10, emphasis on the fact that prevent relevance is much broader than pursue relevance.
Correct.
Page 11, any such case must be referred to a prevent inspector who must have oversight pre-closure if the recommendation is for closure.
That's correct.
And must also be referred to the CT Clinical Consultancy Services, the successor to the Vulnerability Support Hubs. Yes?
That's correct.
There's also at page 16 highlighting the risk of disguised compliance in these cases. Would you agree?
Yes.
Beyond those steps that obviously you have been closely involved in of repeat referrals and emphasising the need for particular care and higher supervision and oversight of the cases around VFI cases, are there any further measures that you can identify that are practicable that would help to ensure that such cases are given appropriately careful scrutiny in Prevent?
I mean, the policy is coupled with embedding this through training, enhanced input. It's one of a number of things, and we are also, as referenced in my statement, actively working on the recommendations that were detailed in the Dignate review, the PLR and Lord Anderson's review. So those are by no means the only actions being taken. We are exploring different policy changes and also working with Home Office colleagues to ensure that we consider all of the things that will help deal with these cases.
Thank you. I want to turn briefly to reviews. So 3 to touch on. one in more detail. You were involved, I think, first of all, in the commissioning of the independent Prevent Learning Review after the attack, is that right?
That's correct.
CTPHQ 4055. Well, that's being brought up. You, as others have done, have flagged two limitations to this. One, it was done quite urgently, so to a short timescale, and it was also while matters were sub judice, so the reviewer was not able to speak to the CTCOs, the CTCO really, and the various sergeants or the FIMU analysts.
That's correct, but I and my senior Home Office counterpart both agreed that it was an urgent requirement to understand if there were anything that we need to act upon to ensure that we changed policy and process to protect the public, and then we could conduct more detailed reviews at the appropriate points.
Thank you. And if we go, please, within this to page 34. Conclusions. Overall, the reviewer considers there to have been a high level of compliance by the Prevent officers with process timescales, assessment completion and adherence to policy that were in place at the time. But although processes and policies have been largely followed correctly, it is the subjective decisions that have come into focus and identified throughout the review are a number of factors that may have impacted on decision-making by CTCOs. And then we see the headings there, the assessments made and opinions of the FIMU, flagging to the risk of preempting or influencing. And the question of ideology and the lack of it is a central theme throughout the handling of all three referrals. Dealing with that aspect, there may have been an overemphasis on the presence of ideology to the detriment of considering AR's susceptibility. These two elements may have been separated and addressed in isolation rather than considered together. And then there's a reference to the joint letter and reference to some considering the joint letter to be ambiguous. Obviously, the reviewer wasn't able to explore that with Constable Thompson. This emphasis on ideology can exist today, and careful consideration needs to be given to referrals in cases where individuals are highly susceptible, easily influenced, but lack a defined ideology. Since April 24, there's been a change in categorization of ideologies for all referrals and cases. If these new categories were applied today, his case could now fall into one of two new categories, either no ideology, other susceptibility to radicalization identified, or fascination with extreme violence or mass casualty attacks. Would you accept all of that?
Yes, I think all of this was written without having heard the granular evidence.
Of course, subject to those.
And we will obviously now examine that carefully and understand if there's more findings that we need to draw, having heard the CCTO and supervisors' accounts of what they did and didn't balance in their decision making.
All right. Can we have from 3 to the bottom of the page? Lines of inquiry were not completed. Potential risk from repeat referrals, and we've touched on that. If we can go over the page, please. Assurance dealt with. Previous case management tracker was closed to all personnel other than authorised police users. Now, that's a slightly wider issue that I don't need to go into for my questioning for you, but I don't want to be said to have overlooked it. And then police-led partnership. This case also raises questions regarding the initial use of police-led partnerships instead of referring to channel. This was done to enable a visit to take place. And the reviewer's comment is this seems unnecessary as the policy allowed for visits to take place during the PGA process if appropriate and by exception. But then this, considering all of the above, in the reviewer's opinion, there were sufficient concerns with the first referral to warrant the case remaining open and being referred to channel, especially in light of the condoning of the Manchester Arena attack. Channel is available to support individuals vulnerable or susceptible to being drawn into terrorism. There is not a need to prove a definitive terrorism connection for channel, only that the individual is potentially at risk of being drawn into terrorism. As the SNC, do you agree with that assessment that there were sufficient concerns with the first referral to warrant the case remaining open and being referred to channel?
My assessment is that there was sufficient for it to move past the PGA stage into the multi-agency information gathering. That would have then allowed all of the available information to be assessed and a 36 decision to be made. It's difficult to predict what they would or wouldn't have got out of that process for the Section 38 decision, but I think the reasonable grounds to suspect test to move past PGA for consideration, yes, I feel that's the case.
And does it follow that in your assessment that the first referral in AR's case should have cleared the PGA stage based on what was known and what could have been known?
I believe it should have moved past the PGA stage. As I say, it's difficult to then predict what would have followed because without knowing what information would have been gathered. But I think it would have aided the decision making.
Thank you. And then we've mentioned the DigNote report already and we've had it on screen. Can we have it back, please? CTPHQ 4028. Can you just help with why there was this second review, just briefly?
So, in normal circumstances, a DigNote review would come first, but because this case was so significant and it felt appropriate that there should be an independent review immediately to ensure that I and my counterparts in the Home Office could get that independent feedback. The DigNote review, however, can be a much more granular and operational review against policy. Not that the PLR wasn't, but they are practitioners within our headquarters department who are going through with a fine-tooth comb all of the policy and just add some richness, really. There was also the passage of time, so we were able to do it slightly slower and gather all of the documents and information available. So it was really to close the loop of all of the referrals that we would normally do in these circumstances. It was just in a different order to how it would be done if it wasn't such a significant incident.
Thank you. If we just go to page 11, please. Final area of my questioning. There's identified a number of learning outcomes. Can we just have the top of the page, first third, highlighted, please? I'm not going to overlook learning observations 1 and 2, but they deal with aspects that I don't need to specifically question you about. But if we go down to the bottom half of the page, please. Learning observation 3, device downloads and internet history, devices seized after the assault allegation were examined, but the results or download themselves were not requested by the CTCO. Do you agree that that is a learning point?
It is a learning point.
And the school browser history not being checked, that's a learning point?
As you can see, the policy position is quoted within the document. My understanding is the officer considered those, but perhaps the action wasn't concluded in the way that would have been helpful and best practice.
So it is a learning point?
Absolutely.
Thank you. If we can go over the page, please. Can the top half be highlighted, please? Learning observation, school massacre as an ideology. The closure rationale for all 3 cases focused on the lack of a distinct CTDE ideology. However, guidance, albeit new at the time of the first referral, stated that school massacre, mass violence should be treated as an ideology in itself. As well as searching for school shootings on the internet, AR acted out behaviours indicative of a school massacre ideology by attending his own old school to attack pupils with a knife and apparently admitted to having a list of targets. It appears this was not identified as a potential ideology or prevent relevant risk and therefore does not feature in decision-making during the 3 cases. A more careful assessment of these factors could have resulted in the case being progressed further. Do you agree with that as a learning observation?
I agree it's a learning observation. I would flag that the officer conducting this review didn't speak into the individual officers, so they were making those
And I
observations.
think earlier we made clear, I hope I drew that
desktop.
out, that it was a desktop review.
Absolutely. So we've obviously heard
Yeah.
the officer account for their own considerations on those matters.
With that caveat, without going through all of the other learning observations, were there any learning observations from the Dignote report where you thought the reviewer has got that wrong, that that's not an appropriate learning observation, that's not something which could have been done better?
I think all of the learning observations are appropriate based on the information they were considering and broadly chimed with those that were found by the PLR. As I say, we will now review, now we have the more granular understanding of the officers' accounts, we'll consider if there's any further learning observations that we need to draw, having heard these, and obviously that's not to preempt the Chair's recommendations, but just to be swift, we will obviously see if there's anything that we urgently need to pick up there as well.
Thank you. There's obviously Lord Anderson's report as well.
Yes,
We're
of
going
course.
to get an update in relation to that. When one takes all of those things together, how confident would you be that a referral in relation to somebody who's a violence-fascinated individual would now be handled better?
Considering the path that has been brought in, the new policy, the raised awareness, I am more confident that those would be handled better and would likely progress through the system unless there was a very good reason or rationale not to that had been appropriately supervised and checked as per the policy.
We dealt with Ms Elsmore, I think you were able to hear it yesterday, about the threshold end-to-end review that was done, where at page 7, paragraph 17, there was an indication that practitioners may still be confused about these matters, and that's very recent, a May 25 report. Does that cause you concern?
Clearly that's a concerning statement. My team and I will work personally with Catherine to understand what that specifically means in relation to police practitioners, because I think, as was outlined, practitioners is a broad group of people in that context, and we will ensure that any findings that have come from that threshold review are then taken and acted upon if there are gaps in the understanding in police practitioners.
Thank you. So I've sought to cover the areas raised, but I'm just turning to my left. I'm seeing shaking of heads. So do you have any further questions for this witness?
I don't. Ms Evans, you've dealt with an enormous amount of material this morning. I'm very grateful to you.
Thank you,
Very
sir.
much. 2 p.m.
Thank you, sir.